Coming in from the Supreme Court, Apex Court has rejected all demands made by petitioners in the VVPAT case. The plea for 100% VVPAT verification has been rejected by the Supreme Court. They have rejected the plea for reverting to ballot paper as well. Bhavtosh Singh is joining us from the Apex Court for more on that. Bhavtosh, big news coming in. Our legal editor Harish Nair has brought us this news that the Supreme Court has junked the plea seeking paper ballots as well as 100% VVPAT counting that the petitioners had wanted.
Yes, Madhav. In fact, our legal editor Harish has broken one of the big news amidst this Lok Sabha elections. Justice Khanna has said that he and brother Judge Justice Dipankar have written two separate judgments, but concurring judgments that they both have agreed with each other. Justice Khanna has said that that both of them have rejected all the demands made by petitioners, that they have rejected the plea of 100% verification of VVPATs, that they have rejected the plea for reverting to paper ballot. Remember, opposition as well as some petitioners have always said that they should revert to paper ballots, and they have the Supreme Court has rejected that, and they have said that voters has no fundamental right to get his or her vote verified through VVPAT, that their votes have been recorded as cast and counted. Supreme Court has also said that in judgment we have also given some directions. So it's a huge setback for EVM doubters, and this is happening amidst Lok Sabha polls, and the second round of Lok Sabha polls are happening, and the Supreme Court has made it very clear that EVM will continue to stay, and they have said that the petitioners' demand that all votes should be counted with the VVPAT slips have also been rejected. Today, that detailed order has not come out. It was Justice Khanna who have said that there are two judgments that are coming, but both of the judges have agreed, and concurrent judgments have been given.
All right, we also have Harish Nair, legal editor, who's brought us this big news. Harish, massive setback for the petitioners. But what are these directions that the Supreme Court has said that they are giving as far as EVMs are concerned? Any details of that are coming out?
Yes, in fact, Madhav, as you rightly said, the big setback for EVM doubters. Remember, at present, only randomly selected 5 EVMs are verified against the paper trail. They had thought that 100% VVPAT should be verified and had raised doubts, cast aspersions regarding the functioning of the EVMs. But Supreme Court has dismissed all those contentions and has said that voting through EVMs will continue, and we will not order 100% verification of VVPATs, saying that it will be a regressive thought, as it will amount to going back to the paper ballot system. Remember, Madhav, in fact, this judgment is perfectly in tone and tenor with the marathon hearing of 3 days, during which the bench had slammed EVM doubters, asking how many petitions will come, and every time a new suspicion, how many times you will raise this issue, and asking, are we not sometimes over suspicious? Supreme Court had also said we cannot issue a direction like mandamus on basis of mere suspicion. Supreme Court had also said don't compare with foreign countries, compare with population. This was when it was argued that European countries like Germany had reverted.
Harish, I'm going to just request you to hold on to your thoughts. I'm going to come back to you. I'm going to give you a few moments to come across live to us as well. But I want to quickly go across to Member of Parliament Mahesh Jethmalani, who's also, of course, a legal eagle in his own right. Mahesh Jethmalani, what do you make of the Supreme Court? This is not the first time it's happening. In fact, the Chief Election Commissioner, during the poll schedule announcement, Mr. Rajiv Kumar, has said that this matter has been tested by constitutional courts and EVMs have been found to be completely above board dozens of times in the past. Are you surprised with this verdict?
No, I welcome this verdict. I think this verdict is a big slap on the face of the petitioners. I mean, you know, there's no, as the Supreme Court pointed out, it was based on mere suspicion. I mean, what kind of pursuit of legal norms is this? I wish they had put an extremely high exemplary cost on the petitioners, because this is a very serious issue. You come to court with a half-baked application, as the petitioners and their well-known lawyer is wont to doing, right? And you start casting aspersions on the democratic fundamentals of this country without any proof. It's a most, you are to the world signaling that our democracy is flawed. Now, you may have a case, but then prove it with facts. not with surmises, conjectures, and political nastiness. You have gone to the depth of politics. You undermine our democracy and our country on the basis just of political malafide.
Right.
This is a ridiculous petition. It is a petition which is anti-national, if you ask me, and it's a petition which was rightly rejected.
All right, all right. Very interesting also, Mahesh Jetmalani, that 2 or 3 suggestions or directions that have come in from the court, and Justice Khanna during the delivery of that particular order said that we have given 2 directions. One direction is that after the completion of the symbol loading process, the symbol loading unit should be sealed. The SLU should be stored at least for a period of 45 days. The burnt memory in the microcontroller of the EVM shall be checked by a team of engineers after the declaration of results on a request by candidates in serial number 2 and 3. Such a request to be made within 7 days after the declaration of results. The expenses of the verification of program to be borne by candidates making the request. In case the EVM is found tampered, the expenses will be refunded. What do you make of these suggestions? Are these welcome as well, or do you see these leading to perhaps more complications?
From them, if you're making it even more foolproof than it is, it's an excellent remedy, and at the same time, right, you are averting frivolous applications for a recount in effect, right, and burdening a candidate who challenges it only because he's lost with costs. So I think it's welcome. I mean, if anything which further strengthens the integrity of the EVM system is always to be welcome.
Right. Right. And what do you make of this narrative that has started? Of course, it's been on and off during various elections. But in this particular election as well, we've been seeing from VVPAT to the EVM itself to whether EVMs can be hacked, several doubts being raised, particularly in poll season. What do you think that this is just a ruse to try and divert from issues in this poll? Why do you think that this issue keeps cropping up every now and then? Mahesh Jetmalani.
The answer, I think, is quite obvious. This is an opposition, right, which knows that it's destined to lose. So they're raising doubts and casting aspersions on the integrity of the system in advance. It's a very, very bad loser syndrome, basically. They're going to the extent of not accepting the expected electoral verdict, right? Only because they are actually anarchists and nihilists. They would destroy a system unless it elects them.
Right. Right. And also from here on, Mahesh Jetmalani, with the kind of action that the court has taken, do you foresee any further such doubts being raised from here on? Do you think that the record has been set straight once and for all by the Supreme Court?
Look, these are eternal dissenters who will eternally cast doubt. It's in their genes. They have never accepted the fact that they are sitting in opposition benches, and those, the extreme left, who found a voice through when UPA governments and Congress governments were there in the past, they are marginalized. They are extremely marginalized, right?
Right.
In fact, I think the marginalization should continue because there are danger to the country and to the democracy.
All right. Thanks so much, Mahesh Jetmalani, for joining us. I'm told that Prashant Bhushan, who is, of course, one of the lawyers in this case, is speaking at the Supreme Court. Let's cut across live to that.
पेपर्स पर अगर हम वो डाल दें मार्क उस पे मार्क डाल दें जिसको बार कोड जिसको कहते हैं बार कोड डाल दें तो उसकी फिर मैकेनिकली मशीन से काउंटिंग हो सकती है कि नहीं, इसको एग्जामिन करें। और दूसरा उन्होंने ये बोला है कि सिंबल लोडिंग यूनिट जो होती है, जिससे सिंबल लोडिंग कंस्टिट्यूएंसी बाय कंस्टिट्यूएंसी करी जाती है, उसको कम से कम 45 दिन तक चुनाव सील करके रखा जाए और चुनाव के बाद कम से कम 45 दिन तक रखा जाए, जिससे कि अगर कोई इलेक्शन पिटिशन फाइल होती है, कोई उसकी कोर्ट मांग करता है तो उसको देखा जा सके। तीसरी बात उन्होंने ये बोली है कि जो इसमें इलेक्शन कमीशन ने बोला कि नहीं, इसमें जो मेमोरी होती है वो तो चिप में बर्न्ट होती है, और तो कोर्ट ने ये बोला है कि जो भी बर्न्ट मेमोरी है उसमें 5 हर असेंबली कंस्टिट्यूएंसी में 5 ईवीएम यूनिट्स की बर्न्ट मेमोरी को एग्जामिन करने का नंबर 2 या नंबर 3 कैंडिडेट दरखास्त दे सकता है, और उसको फिर एक टेक्निकल टीम एग्जामिन करेगी, लेकिन उसका खर्चा उस कैंडिडेट को देना होगा जो उसकी मांग करता है। ये कह के उन्होंने ये सारी पिटिशन डिस्पोज ऑफ कर दी।
प्रशांत?
All right, that's Prashant Bhushan talking about the safeguards that have been spoken about by the Apex Court. We're going to slip into a break now, but a big story that's coming in from the Apex Court as far as the EVMs and VVPATs are concerned. The Supreme Court denying the request of the petitioners to either revert to ballot paper or 100% counting of VVPATs as was part of that particular plea. Big story. We'll be coming back to this after this very short break.